In the next 30 minutes or so, you'll discover why you should plan, who should plan, what's in an effective estate plan, when you must plan, and how to get started with an effective, epic estate plan. This is for you if you're curious about planning, know that planning is important but don't know where to start or what to do, frustrated with the thought of putting your family through probate, you're worried about the future, and security of you, your spouse, your family, or your money. You're concerned about who will help you when you need help the most, and many more reasons. Imagine you could wave a magic wand to prevent probate, avoid unnecessary taxes, protect your family and assets now and later, and stop worrying so you get peace of mind, all at a reasonable price. How would that make you feel? How much peace of mind and confidence would you get? That's what I'm going to show you how to do today. Why should you listen to me? Let me ask, if you don't do anything, in 6 months, will you still be worrying about this? Will you be frustrated because you haven't got around to it? Will you be disappointed because you're not protecting you, your family, and your money like you should? Lynn said, Gary helped us get our affairs in order before our trip to Israel. He gave us peace of mind, knowing everything was taken care of for our family. Gary is so easy to work with. We could not have been more pleased with him and his lovely wife, Winnie. We highly recommend DeWitt Law Firm for all your estate planning needs. When I was 40, my dad passed away unexpectedly. Mom and I had to struggle through the rigors of probate. Neither of us had done this before and were lost, confused, and worried for the entire time it took. Dad had a little money in a lot of places, and we had to find all of it. We had to find all the property, catalog it, inventory it, and then distribute it. And all of this had to be done under the oversight of a judge and the attorney. Plus, the attorney was billing us for every minute of time. Then later, that same year, I was hospitalized with chest pain. It wasn't a heart attack, but it made me take a good long look at my life. And while I was laying there in the hospital bed, I was worried about the future of my family. I was worried about both their financial security and their personal future. I was worried about who would make my decisions if I took a turn for the worse. So laying there in the hospital, I knew there had to be a better way to do things. So I made up my mind then and there to go to law school, become a lawyer, and help people avoid probate and worry less about their future, their family, and their money. And that's just what I did. I went to law school at 40 years old, learned as much about estate planning and elder law as I could, and opened a practice to help you get peace of mind. Furthermore, I completed an advanced law degree in estate planning and elder law to better help people. After finishing, I knew how to help people and avoid probate, control their destiny, and get peace of mind. I wanted to help people, but they were afraid if they called, I would send a bill, so I decided to practice a different way. I decided to find a new way of working with clients to plan for their future, so when they needed me, they wouldn't have to worry about getting a bill. Now clients can call me whenever they need to. Now I work with people like you every day to protect them, their family, and their assets so they can get peace of mind knowing they have taken care of everything they can take care of. And they don't have to worry about calling later with questions because I'm not going to start the clock to create another bill. That's why I created Epic Estate Planning. It's different. To start with, we guarantee our quoted fee. No matter how much time we put into your plan, the fee won't change. We also guarantee your meeting to start on time. Michael shared, I love this place. Top shelf legal help for wills, estates, trusts, etc. They are hardworking, approachable, caring people with their clients' best interest in mind. I'm teaching this because of my father's probate. Nobody needs to put their family through probate and or more, and I love helping others. Today I'm going to cover who needs a plan, when you need to create your plan, why you should plan, the documents that make up a plan and what they do, and how to get started. Everybody over 18 needs some estate planning. I'll be talking about the reasons why in just a few minutes. I have an estate. You have an estate. Your property, that is your computer, phone, tablet, house, cars, 401k, life insurance, jewelry, clothes, and more is your estate. Your property is your estate. Planning protects property. If you don't write or haven't written your own plan, then the government, legislature, and courts have a complex plan written for your estate and how it goes to your loved ones. This is your default plan. Leave it up to the legislature and courts to make a convoluted system to pass your property and manage your affairs. And if you only have a will, you must still go through probate. Wills alone don't prevent probate. Even if you own everything with somebody else, sooner or later there is only one owner. And putting your children on the deed and accounts has its own dangers. By making them the owner or part owner, they can spend the money or sell the property without your permission. Their creditors will have access to the assets. If they have an accident and are sued, the other side can get to those assets. Without a will, the law tells the judge who gets how much and when. However, it doesn't tell the judge what each person is to get. With a will, you tell the court who gets what and how much. Everybody needs to have their own plan to protect property. If they don't write their own plan, they get the government's plan. Leave it up to our legislature and courts to produce a convoluted, complex system to decide who takes care of people and how their stuff passes to the next generation. To avoid using the government's plan, people need to write their own plan. Writing a plan ensures their wishes and stops the government's plan. Estate planning can be broken down into several small steps that, when put together, end in a complete plan. The first step is to start getting basic biographical information together. That is, the things children will need to know later. For example, your full legal name, mother's maiden name, your military experience, and when you served. Lori says Gary DeWitt is an incredible attorney. He and his wife Winnie are sincere, down-to-earth people who just want to help keep your estate out of probate. You can't predict the future. The time to plan is before anything happens beyond control, while thinking clearly and capable of making informed decisions. So many things can cause you to be unable to make informed decisions and be incapacitated. Plan now in case of sudden incapacity, whether temporary or permanent. Accidents and medical incidents often strike without warning and lead to sudden, sometimes permanent incapacity. That is, the loss of ability to make informed, rational decisions. Medical incidents can strike anybody at any age, even those that appear healthy. For example, on February 25, 1990, at age 26, Terry Schiavo suffered a heart attack. She was successfully brought back, but had massive brain damage because of lack of oxygen during the heart attack. She was left in a comatose state. After several months of no improvement, that diagnosis was changed to a persistent vegetative state. For 2 years, therapists attempted to bring her back to the state of awareness without any success. In 1998, Terry's husband petitioned the court to have her feeding tube removed. He was opposed by Terry's parents. Mr. Schiavo prevailed. Within a few days, the feeding tube was put back in. In February of 2005, another court ordered the feeding tube removed. Appeals and federal government intervention followed. Finally, the federal court sided with Mr. Schiavo and ordered the feeding tube removed for the last time. In all, the case involved 14 appeals, 5 lawsuits in federal court, and more. And after she passed, the autopsy showed extensive brain damage, with the brain only weighing half of what it should have. Most, if not all of this, could have been avoided with a proper plan. Because Terry didn't have an advance directive, also known as a living will, her family had to go to the court and get permission to manage her medical care. She should have also had a healthcare power of attorney and durable power of attorney. While this is an extreme case, if you pay attention to the news, all sorts of otherwise healthy people have medical incidents. Any number of accidents can lead to an injury that causes incapacity. Falls, auto accidents, bike accidents, and more. Accidents don't discriminate because of age. Accidents don't discriminate because of health. Wet floors, ladders, and more are dangerous around the house. Driving is fraught with dangers, including inattentive drivers texting and talking, and drunk drivers. Finally is dementia of all sorts: Alzheimer's disease, vascular dementia, Lewy body dementia, and more. Dementia most of the time sneaks up on people and robs them of their ability to manage their affairs, money, and health care. Related to dementia is delirium caused by illness or medication. In the elderly, delirium caused by medication is often confused with dementia. I had a client who was declared incompetent by the courts. When the guardian had the narcotic medication stopped, the lady's mind cleared up and she returned to normal function. We went back to court and had the guardianship removed. I can't begin to remember the number of times a child is called wanting or needing a power of attorney over a parent, and I have to tell them, if mom or dad can't make informed decisions, then I can't just write them a power of attorney. A person must be able to make rational, informed decisions and have the mental capacity to sign a contract before they can be allowed to sign a power of attorney. It's never too early to start planning. People tend to put off planning. Too many people who need a plan never got round to it are under the control of the state's plan instead of their own plan. If you didn't know, the legislature and courts have created a default plan for those who don't write their own plan. Decide now is the time and get your plan started and done before it's needed. With the proper help and planning organizer, it won't take long to get organized and get everything you need written down. Later, we'll go over how to get your planning organizer. Gary was so helpful when we planned our estate with he and Winnie. Professional, and I can ask him a question anytime. We love Gary and the DeWitt Law Firm. There's more to estate planning than just deciding who gets your stuff. You also get to decide who will be able to legally help you when you need help. Powers of attorney help you and your family avoid court. Powers of attorney help you protect and preserve assets and dignity while living. They also make sure that somebody you know and trust is there to help you. Many people confuse a trust and a durable power of attorney. There are certain things you can't do with a trust. You can't give people the power to sue on your behalf or manage assets not in the trust. A trust can't outline your medical decisions or give people permission to talk to doctors and nurses. A trust can't manage insurance policies it doesn't own. If you have a trust, you still need a durable power of attorney. If you don't have powers of attorney for financial, legal, and healthcare decisions, then your family could end up in court to get permission to make your legal, financial, and healthcare decisions if you can't make rational, informed choices. This is called guardianship. Every person has a personal reason to plan. I'm going to go over some of the most common ones in no particular order. One of the top reasons people plan is to prevent probate. Leave it up to our legislature and courts to have a complicated, cumbersome, slow, convoluted system to pass your property to your family. Probate is expensive, time-consuming hassle for families. Probate will take a minimum of 8 months and 6% of your gross estate. Your gross estate doesn't subtract out debts like the mortgage on your home, even if you have little to no equity. So, if you own a $200,000 home with a $190,000 mortgage, your family will still pay 6% of the $200,000. That is, $12,000 to probate the house. Without a plan, the legislature has decided, and the court enforces, how much each family member gets, when they get it, and how they get it. Just for this presentation, I downloaded just the laws covering administration of an estate without a will. After waiting for it to download, it was 365 pages, and that doesn't include the court rulings on those laws. People will fight for the cherished little things as much or more than they'll fight for a pile of money. After all, there's only one of a photograph or memorabilia that was cherished by your children. This story from CNBC illustrates why you need to consider the little stuff too. If you want to avoid family fights over your estate, take a long, hard look at your closet. Personal property is something that people often fail to consider when drawing up wills and other estate planning documents Attorney John J. Scroggins told an audience of financial planners last week at the FPA-B conference in Nashville. The single biggest point of conflict amongst family members is not the $1 million over here, said Scroggins, who is an accredited estate planner and partner. It's the yellow Tweety Bird figurine that sat in Mom's kitchen for 40 years. That story illustrates the importance of considering everything. By the way, the family fought over that yellow Tweety Bird figurine in a fight that cost tens of thousands of dollars. If you have minor children, you can use a will and durable power of attorney to nominate the guardians for them. If you don't nominate a guardian, then the judge won't have your guidance as to who you wanted to raise your children if you can't. With a trust-based plan, you have long-term control of the money and property in the trust. You set the rules for others to follow. For example, if you have one child that just can't manage money and is in a lot of debt, you can either have the trust pay them an allowance or hold the money until they are older and wiser. If you have children with addictions, then you can use the trust to manage their money without feeding those addictions. The same for children with marital issues. You can keep the money away from their spouses. Special people need special planning. Families often must fight to get their children the benefits they deserve. If those children are left a lump sum straight out, then they could easily lose those benefits temporarily or permanently. If your children don't qualify for any benefits but still need help, you can structure a trust to help them without giving them a lump sum payout. If you have children with addictions, then you can use a trust to manage their money without feeding that addiction. It doesn't matter if the addiction is drugs, alcohol, QVC shopping, excessive spending, or gambling. You can protect them from their habits. You can set up a trust to pay their rent, pay their utilities, and buy them groceries without giving those children money directly. Nobody but you has the legal authority to make your financial, legal, and healthcare decisions without a power of attorney. If you don't have a power of attorney in place, then somebody will have to step up and go to court in an expensive and nerve-wracking process called a guardianship. In the guardianship, the judge makes the judgment call that you are not capable and gives permission to somebody else to make your decisions. Wills don't give you lifetime protection from guardianship or protect your money. With a plan, you choose how your assets are managed, how your affairs are managed, and who will manage them. It's never too early to start planning. People tend to put off their planning. Too many people who need a plan never got around to it or are under the control of the state's plan instead of their own. If you didn't know, the legislature and courts have created a default plan for people who don't write their own plans. Decide now is the time and get that plan started and done before it's needed. With the proper help and planning organizer, it won't take long to get organized and write everything down. If you need a professional and reasonably priced lawyer in Northwest Arkansas to finally get a will made or other lifelong planning, I highly recommend Mr. DeWitt. His free book is a wealth of information. There's more to estate planning than just deciding who gets your stuff. You also get to decide who will be able to legally help you when you need help. Powers of attorney help you and your family avoid court. Powers of attorney help you protect and preserve assets and dignity while living. They also make sure that somebody you know and trust is there to help you. Many people confuse a trust and durable power of attorney. There are certain things you can't do with a trust. You can't give people the power to sue on your behalf or manage assets not in the trust. A trust can't outline your medical decisions or give people permission to talk to doctors and nurses about your condition. A trust can't manage insurance policies it doesn't own. If you have a trust, you still need a durable power of attorney. If you don't have a power of attorney for financial, legal, and healthcare decisions, then your family could end up in court to get permission to make your decisions. This is called guardianship. There are several documents you should have in your plan. A durable power of attorney to cover financial and legal decisions. A healthcare power of attorney for health choices. A protected health information release, also known as a HIPAA waiver. Without this, your family can't get updates on medical conditions easily. A living will or advance directive. This tells the doctors what treatment you want if you are in a vegetative state or can't otherwise make medical decisions and the end is very near. An advance directive, also known as a living will, tells your family and doctors your final healthcare wishes. In it, you decide what treatments you want and don't want if you are hanging on by a thread and it is quickly fraying. Don't confuse this with coming into the emergency room from an accident and you have a good chance of recovery. A living will is only used in the end. If Terry Schiavo had had an advance directive, she wouldn't have laid in a hospital bed for 15 years while her husband and parents fought over her health care. Without a release, doctors and other healthcare professionals can't share medical information with family and friends. After the mass shooting in Florida at the Pulse and Orlando Hangout, there was mass confusion about HIPAA laws and what the doctors and nurses could share with family and friends. If these people had releases done, there wouldn't have been that confusion and reluctance to talk. HIPAA allows doctors to reveal information when appropriate, but doctors are often reluctant to talk without a release in place because the fine for revealing protected health information could be up to $50,000. A durable power of attorney tells others who you want to manage your affairs when you can't. It can be limited or open as you want. The more limited it is, the greater the chance you will have to face the expensive guardianship proceedings in court. You want to make sure it's durable. Otherwise, if you become unable to manage your affairs, the power of attorney stops. With a durable power of attorney, a trusted person will be there to manage your financial and legal affairs. They can take care of things like paying bills, responding to mail, bank for you, and manage investments. Taking a short amount of time to create a durable power of attorney is well worth the small effort it will take. If you don't have a durable power of attorney, your loved ones may have to go to court to get authority to manage your affairs. This is much like a durable power of attorney, only for your health care. This document tells the world who you want to make healthcare decisions when you can't. Without it, the doctors have a list of people they will take advice from, but then the final decisions are theirs. A will is really nothing more than a list of instructions on how to pass your property to the next generation and nominating somebody to care for minor children. It also names somebody to oversee taking the document through court, the executor, to manage the property until its final distribution. A will requires probate to be validated and activated. A will, plus some additional planning, will prevent probate for your major property, leaving only the little stuff. A will requires probate to be validated and activated. A will, plus some additional planning, may prevent probate for your major property, leaving only the little stuff. You can be very detailed in the instructions, or you can be very terse. I've seen wills from 1 page to 40 pages. Wills require probate to be validated and for the property to be passed out. That's right, wills require probate. Wills are just the instructions to the probate court. Keep this in mind. A will can create a trust. It's called a testamentary trust, and they have their place. Also, a will does nothing during your lifetime to protect you, your money, or your rights. In order to avoid probate with a will, you need additional planning. The goal is to get as much of your estate passed outside of probate as possible and use the will as a catch-all for anything else. Your will should just cover the little stuff if there's anything at all left outside of probate. Your major property should be set up to pass outside of probate. Bill thought that just his will would prevent probate. But just a will doesn't prevent probate, as Bill's family discovered when they tried to sell his house. Instead of being a smooth, quick transition, Bill's family had to go through the expense, time, and hassles of probate to get the house sold and estate settled. If Bill had done some additional planning, his family could have avoided probate to sell the house. The person creating a trust is called the trustor or grantor. Grantor simply means they granted property to the trust. The person who legally owns the property and manages it is called the trustee. The person who gets the benefits of the property is the beneficiary. A trust is a contract between two people, the trustor and trustee, for the benefit of a third person, the beneficiary. A living trust is created during your lifetime. A testamentary trust is created in a will. The most common type of trust used in estate planning is the revocable living trust. Revocable means that it can be changed during your lifetime. Living means you set it up now. With the trust, you're usually the trustor, trustee, and beneficiary during your lifetime. However, if you should become incapable of managing the trust property, you can name somebody else to step in and manage it, your successor trustee. When you pass, the trust usually becomes irrevocable and its instructions are carried out by the trustee you name, all without probate. The advantages of the trust is the trust property is managed during your lifetime and probate is avoided for all the property in the trust. This picture can help understand what a trust is. A trust is really nothing more than a contract between a grantor and a trustee for the benefit of a third person, the beneficiary. The grantor transfers assets to the trustee. The trustee manages the assets for the benefit of the beneficiary. The most common trust to prevent probate and manage assets is the revocable living trust. With that trust, while you are capable, you are the grantor, trustee, and beneficiary. The trust or trustee owns the property and you control the trust. Therefore, you control the property in the trust. James didn't think he would ever need an estate plan, but in his 60s he developed rapid onset dementia. Because he didn't have a plan in place, his son had to go to court and get a guardianship to manage James' money, property, and health care. And when it came time to sell James' house, he had to spend more money, go back to court to get permission to sell the house. And if James' daughter had fought the guardianship, it would have been worse and more expensive. Barbara's mother started buying everything and anything from anybody that was selling. She lost her ability to say no to any salesman. Fortunately, Barbara had a power of attorney in place that allowed her to take control of the accounts and contracts and stop her mother from buying from every telemarketer and door-to-door salesman. Later, when Mom moved to assisted living, Barbara could handle selling the house and taking care of everything else without going to court. Estate planning can be broken down into a set of steps. I've talked about a few of them. The next steps are to assess assets, that is, what is owned and what is owed, and write it down. Decide who fills the various roles in the plan, and get your plan implemented in a legally binding way. While this may sound like a daunting task, with the right guidance, it's not nearly as hard as you think. I've spent a lot of time, energy, and money developing a system to guide people along in the easiest, shortest way possible. If you'll hold on just a minute, I'll share with you how you can get that system started. We have used DeWitt Law Firm since coming to Springdale. They walked us through every step of estate planning and what to do when. Gary and Winnie have huge hearts and the knowledge you need to protect your assets. So far, you've discovered who needs a plan, when to plan, why plan, what's in a plan, and some of the steps to get started. Get this one thing. You're going to have your financial house in order and know that you and your loved ones are going to be protected. And you, personally, are going to feel good. Your stress will be relieved because you know that you've taken care of your family and everything you can take care of. Get peace of mind and have confidence that your family is protected. You have two choices. You can either use the trial and error method or use my proven system. Epic Estate Planning was developed to streamline the process and make it as easy as possible on you while creating a high-quality plan for you and your family. EPIC stands for Evaluate, Produce, Implement, Calm. We evaluate your goals and talk about your wishes to produce a unique, complete, customized plan for you and your family to ensure your wishes are carried out, prevent probate, minimize family fighting, and reduce taxes so we can implement your plan to make it legally binding and fund as needed to calm your nerves and give you peace of mind. The first step in EPIC planning is to evaluate your goals and wishes by talking to you in a free 1-hour meeting. The Family Resources Objectives Meeting, FROM. Why do I call it FROM? It helps you move from disorganized and no plan to organized and planned. In your From meeting, you get 1 hour of my time. Unlike a typical 15-minute phone consultation, you won't be rushed to get your questions answered and then pressured to sign up. Everything we discuss is completely confidential. What's said in my office stays in my office. That's right, you're going to get 60 minutes of my time to go over your goals and wishes, answer questions, and then outline the plan that is best for your family. It really does take about an hour for us to get to know each other, go over your goals, understand your family, and outline your plan. During this time, I'll do my best to educate you on your options and what they mean. However, if you have any lingering questions after our meeting, feel free to pick up the phone and give me a call. Once done, you have the choice to shake hands and leave without obligation or continue on and create your personalized plan. I normally charge $2.25 an hour for my time, and some lawyers would charge for the initial meeting. I've been there and done that. Not only do I have a family to protect, I had the family farm that I've had to plan for. In addition to a law degree, I've received an advanced law degree in estate planning and elder law. Many hours have been spent streamlining and simplifying the planning process so that you don't have to spend an excessive amount of time on your side. Also, experience has shaped and guided my document creation. I stand behind what I do. I know my stuff stands up in court because I followed it through in many cases. And speaking of court, I also do probate work, so I know what you need to do for your family to avoid probate and simplify things for your family and loved ones. The cost of attending those classes and gaining that experience was quite high. I wrote the book, Secrets of Excellent Estate Planning, to educate you in an easy-to-understand way in the comfort of your own home. And I'm going to make sure you go home with a printed copy if you don't already have it. And there's more. Once you complete the organizer, you will have your financial house in order. All you need to do is fill it in. 90% of the hard work has been done. And this is all the information needed to complete your plan. You'll have the information your family will need to find in one easy-to-find location. A lot of time and effort has gone into making this organizer complete and easy to fill out. And there's even more. Also known as a living will, this document describes what treatments you want or don't want in your last hours if you can't make those decisions. I'll make sure you go home knowing how to fill it out and what is required to make it legally binding. Let's go over everything you'll receive when you act today. The total value of your EPIC plan and family resources objectives meeting is 1 hour of my time, professional expertise, the book, an estate organizer, and a living will. What would it be worth to have your financial house in order and know that you and your loved ones are going to be protected, and that you personally are going to feel good? Having your stress will be relieved because you'll know that you've taken care of your family and everything you can take care of. What is peace of mind worth? The total value of this consultation with everything you get is over $882. But if you're one of the first 10 people to make an appointment this month, you can get it for not $882. I've opened 10 spots where you get your meeting free of charge and without obligation. I guarantee if your appointment is more than 15 minutes late, I'll give you $50. No one likes financial surprises. That's why on every project we will provide you with a written fee quote. No matter how long it takes us, it will never cost you 1 penny more. Once we quote a fee, we stick to it no matter what. You can depend on it. To get started, call 479-717-6300 now to book your appointment. Our phones are answered 24 hours a day, 7 days a week. Or you can visit www.planwithgary.com. Remember, you're going to get a 1-hour appointment, professional expertise, your questions answered, the planner, the advance directive, my personal guarantees, all in a relaxed environment today for only 3 payments of nothing. Call 479-717-6300 now to book your appointment. Our phones are answered 24 hours a day, 7 days a week. Or you can visit www.planwithgary.com. Remember, you're going to have your financial house in order and know that you and your loved ones are going to be protected. And you personally are going to feel good. Your stress will be relieved because you know that you've taken care of your family and everything you can take care of. Get peace of mind and have confidence that your family is protected. Call 479-717-6300 now to book your appointment. The phones are answered 24 hours a day, 7 days a week. Or you can visit www.planwithgary.com.